I was recently asked a very good question regarding the usage of drones in the private investigations industry as it relates to surveillance in the future. And this question did make me pause and think a bit. I want to know your thoughts on it also, so head down to the comments section down below and let me know. The question is, do you think drones will just do surveillance in the future? When I first started thinking about this question, my mind was going 100 miles an hour. I had thoughts about the requirements of flying drones, the legality of flying them and obtaining video, the permissibility of flying drones over private and public airspace, and the list goes on and on. In order for me to get a good grasp regarding the question, do I think drones will just do surveillance in the future? I first had to answer some questions. First, I want to be very clear. I am not an attorney. I am not giving legal advice. This is simply my personal opinion based on what limited knowledge I have regarding the subject. If you are using drones in your private investigation business, or in any business for that matter, I would suggest you seek your own legal counsel as to what is permissible and not permissible. One big question that comes to mind that must be first addressed is, who regulates the usage of drones? Well, a simple answer is the FAA, or the Federal Aviation Administration. They are primarily responsible for the regulation regarding UASs, or unmanned aircraft systems, which is what a drone legally is. And the FAA legal description of a drone was quite a surprise to me, and some of the legal ramifications regarding that description is also extremely important, and we'll discuss that in just a little bit. Now, you may be wondering, why is it necessary for the federal government to get involved in the regulation of drones? Really quick, let's take a look at some numbers. According to the FAA, there are over 870,000 registered drones in the United States. You heard that correctly. There are over 870,000 registered drones in the United States. And one thing I know about statistics like this is if there are over 870,000 registered drones, there is probably a significant number of unregistered drones out there too. Another fun fact from the FAA, out of those more than 870,000 registered drones, nearly 332,000 of them are commercial drones, and there are nearly 535 registered recreational drones. These numbers are staggering to be sure, but what category does the private investigations industry fall into? According to FAA regulations, if you are using a drone for any commercial use, then you must have a commercial drone pilot's license. And any commercial use means if you make any money regardless of the amount from flying a drone, you are using it for commercial purposes. So if you are using a drone for surveillance, you probably need to make sure that you have that commercial license in place. But is that the only cause for concern if you are using a drone for surveillance purposes? Another thing we must consider is the legality of obtaining video. When can we obtain video? Where can we obtain video? And is it even admissible in court? As a general rule, in most cases, we can obtain video of anything that is in public view. So the question then is, what is in the public view? It may be easier to look at the opposite, what is not in the public view. Plenty of case law in the past supports this little thing we call reasonable expectation of privacy. Logically, a person has a reasonable expectation of privacy when they are in their home. They would also have a reasonable expectation of privacy if they are in their backyard and they have a privacy fence. Given that you can't stick a camera up over a fence, shoot video through a knothole, or obtain video of them in the backyard with a drone. And for the most part, even though whatever a person is doing inside their house may be visible to everyone in the world through the front window, the argument is that they still have a reasonable expectation of privacy, and obtaining video through a window by means of a drone or any camera would not be allowed. But what about flying the drone over someone's property? Is that even legal in and of itself? Well, according to what is often referred to as ancient law, you own the airspace above your property to the ends of the universe. However, and there is always a however, folks, the air is generally also referred to as public airspace and is considered part of the public domain. So, the airwaves above your property can be used, in essence, as a public easement, if you will, for an aircraft to fly over the property. And according to the FAA, a drone, a UAS, is classified as an aircraft. Now, the airspace above a landowner's land is owned by the landowner to the extent that the airspace is used to benefit the underlying use of the land they own. I know this is getting complicated, but hang in, it gets even better. Now, a lot of people are going to probably bring up United States versus Causby from 1946, so let's take a quick look at that case. In this case, in summary, the respondent owned property and a chicken farm near an airport. The government had a lease on the airspace from 1942 for emergency uses that would go until 1967, or 6 months after the end of a national emergency. The complaint that was filed stated that the government was flying airplanes over the property at dangerous levels. Now, I am paraphrasing, so bear with me on this. The claim stated that this essentially destroyed the use of the property as a chicken farm, caused loss of sleep, nervousness, and fright on the part of the respondents, and they sued for damages alleging a taking of their property, as well as damages to their chicken farm business. The more important fact regarding this case was in the findings of the court, which found that the government had taken an easement over the respondent's property, and that value of the property destroyed and the easement taken was $2,000. There are two of the many findings from the court I want to look at closer here. The first being, a servitude has been imposed upon the land for which respondents are entitled to compensation under the Fifth Amendment. And the second, the common law doctrine that ownership of land extends to the periphery of the universe has no place in the modern world. Regarding our discussion, both of these findings are key. The servitude being imposed upon the land and the premise that ownership of land extends to the periphery of the universe has no place in the modern world. Now, I am paraphrasing again here, but essentially the court found that there were damages for the property owners due to the amount, the frequency, and the level of flights over the property. So if someone flies over someone's property one time would, in my humble and not legal opinion, not cause harm to the individual in most cases. And since it has been determined that there is, for a lack of a better term, an easement in the airspace above the property, then flying any aircraft over the property would also not be considered trespass. And the FAA does classify a drone as an aircraft if it is following all of the rules and regulations regarding drones. Thus, being an aircraft, it is technically allowed to fly in your airspace because it is considered navigable airspace. I know you may not agree with this. I am not here to argue it, and I am not saying that I agree with it either. I am just letting you know the way I interpret it based on what I have studied. Now, if someone thinks a drone flying over their property is spying or surveilling on them or doing something else that is detrimental to the landowner or their business, then there is probably some legal recourse through local and state laws that would prohibit it. But regardless of state or local laws regarding drones and how they can or cannot be used, those local and state laws cannot prevent the flight of a drone or any other aircraft over any property which is allowed according to federal law. Those laws can only prohibit or restrict certain uses of a drone. Now, I know some of you are probably thinking, yeah, I would just blow that drone clean out of the sky if it flew over my property. And I understand your frustration, but again, let's consider one thing. Federal law defines an unmanned aircraft system, a UAS, which is what a drone is, as an aircraft. And if you disable an aircraft as a civilian by whatever means, be it throwing rocks at it or shooting it down, you could be charged with a federal crime. So the question, do I think drones will just do surveillance in the future? My honest opinion is probably not. There's also another huge thing to think about with drones doing surveillance. If it is just a drone doing the surveillance and capturing the video, then when it goes to court, there is no one to be cross-examined. It would sound kind of silly. Mr. Drone, did you see Mr. Smith with your own eyes walking without use of his cane? You see, the other side has the right to cross-examine the witnesses and the investigators on the opposite side. And if it is just a drone doing the surveillance, even if you can get past all the legal mumbo-jumbo about whether you can or cannot fly a drone and all the wheres and the whens involved, you still cannot cross-examine a drone. But can a private investigator use a GPS tracker? Have you ever wondered about that? Well, then you need to watch this video next.